Civil liberties are liberties given to people which asserts that the government cannot infringe on individual freedoms. So through this presentation, we are going to take a look at our Bill of Rights and what they exactly mean. The Bill of Rights sets limits on government, but people do not have complete freedom to do whatever they choose. In order to protect the common good, there are limits on individual liberties and rights. The framers argue that ideal government was one that limited liberties as little as possible. Personal freedoms would be limited when one person's exercise of a freedom harms another person. So, for example, government can limit free speech in wartime when that speech might aid enemy, such as publishing information about tactics of our soldiers. The Supreme Court has been handed tons of cases that deal with protected freedoms over the years, and they continue to do so. While the justices do not always agree in their opinions, the rulings of the court is the final decision. So how many of the Bill of Rights could you name right now? Could you name them all in order and describe what they stand for? If you can and do understand them, you probably do not need to watch the rest of this video. However, otherwise, you should keep watching. Our First Amendment describes 5 freedoms. These are freedom of speech, freedom of press, freedom of religion, and the right to assemble and petition. Today, you are allowed to believe in any religion, provided you do not break any laws while exercising those beliefs. You are allowed to say, write, and publish whatever you wish, but you must be willing to accept the consequences if you lie or slander someone. Libel is written lies, and slander is spoken lies, and you can be sued for these. You can show your discontent, disapproval, or dissatisfaction with government by holding a protest, but it must be in a public place and it must not be breaking any laws. When we talk about freedom of speech, there is a national freedom of speech, yet anything that creates a riot or is threatening in nature is not permitted. However, our Supreme Court has ruled that hate speech is permitted, and this was decided in the case Snyder versus Phelps. In 2010, a Kansas-based anti-gay church picketed the funeral of a Marine who was the son of Mr. Snyder. He died while on duty in Iraq. The church group believed that soldiers' deaths are a form of punishment against America for tolerating homosexuality. A Maryland jury found that the picketing and internet postings by the group targeted the soldiers' parents and intentionally inflicted emotional distress. Yet the Fourth Circuit overturned the jury's award, noting that the group complied with all local ordinance and expressed only their opinions. Well, the case moved to the Supreme Court, who also ruled in favor of the church group. They stated, "We cannot react to Snyder's pain by punishing the speaker. As a nation, we have chosen a different course, to protect even hurtful speech on public issues to ensure that we do not stifle public debate." Now, many of us may morally or ethically believe that what the group did was wrong, but we have to look at it from law, and law says that hateful speech is tolerated. So what about symbolic speech? We have flag burning, picketing, and draft card burning. You could read more about that in the United States versus O'Brien, which was a case in 1968. We do have the right to burn our flags. That is protected under the First Amendment, and so is picketing. We can do that providing that we've gathered the proper permits and are not inciting any type of riot. What about religion? Under religion, we have the Establishment Clause and the Free Exercise Clause. The Establishment Clause basically says that we do not set a state or national religion. There is also the Free Exercise Clause that we are able to practice what religion we want. Of course, there are exclusions in the Free Establishment Clause, such as polygamy, as the early Mormons did. It is illegal to pray in school. This used to take place, but was ruled as unconstitutional. We also have the Lemon Test, which is the result of Lemon versus Kreutzmann, that found that any state laws that established a religious body is a violation of the U.S. Constitution. There are 3 criterions with the Lemon Test law, which consist of having a legitimate secular purpose, does not advance or inhibit religion, and does not result in an excessive entanglement of government and religion. So the Second Amendment was originally intended to keep the government from abolishing or infringing on state militas. The United States v. Miller and the District of Columbia v. Heller both changed how we look at that amendment and basically said that as individuals, we do have the right to bear arms. Now, there are some exceptions to those. Felons cannot bear arms. You have to be of a certain age. But basically, the Second Amendment gives us the right to carry. The Third Amendment was created in response to British laws before the Revolution. The British were allowed to house troops in homes of colonists against the colonists' wills. Today, this doesn't really affect us much, but it is still in our Bill of Rights. Search and seizure is kind of the heart and soul of the Fourth Amendment. This restricts police from stopping and searching you without a reason, of course, unless there is probable cause. If the police stop you for a traffic violation, can they search your car? Yes, if they have a probable cause, they can. What about third-party consent? That's when another person gives permission to the police to search another individual's property. A landlord can grant police access to search a tenant's apartment. Parents can allow police to search their children's rooms. We have 3 general rules for third-party consent. Husbands and wives may grant consent. Parents can consent to search their children's rooms, and lockers can be inspected as they are property of the school. Under the Fifth Amendment, we look at due process. These are steps taken from the time you are arrested to the trial, and that each step is done in a fair manner. Arraignment must occur shortly after you are arrested, meaning that you face a judge who will tell you what you are charged with and will ask you how you will plead. And at that point, you will also be set up with a bail. You also have a right to a grand jury to determine if a trial should be held. Under the Fifth Amendment, double jeopardy exists, which means you cannot be tried for the exact same crime more than one time. This is once a verdict is reached in court. And self-incrimination. You do not have to answer questions either from the police or in court that may make you look guilty. So you've often heard the expression, I plead the Fifth. You have the right to remain silent under the Fifth. Anything you say can and will be used against you in a court of law. This is the Miranda warning, and police must read this before they question you. Under the Sixth Amendment, we have the right to a speedy trial. Once indicted by a grand jury, a trial must happen as soon as possible. You have a right to a public trial that will happen in a public court of law, and you have a right to a jury trial, which is a trial that must have a jury made up of everyday people. You have right to subpoena. A subpoena is a court-ordered paper requiring you or someone else to testify in court. It is illegal to refuse to testify if you are issued a subpoena. And finally, you have a right to an attorney. This information is also contained in the Miranda warning, and it states that if you cannot afford an attorney, one will be provided to you. The Seventh Amendment has to do with civil lawsuits and not criminal lawsuits. If two people disagree on a contract, or if someone buys something that doesn't work, you can take a person or a company to court. This is called a civil case. In civil cases, you are allowed to have a jury trial. Civil court juries do not rule guilty or not guilty, but instead rule in favor of one party or the other. They also do not need to have a unanimous vote to reach a verdict. It is possible also for you to be tried in criminal court and also in civil court. If you look at the case of O.J. Simpson, not only was he tried in criminal court, one of the victims that he allegedly killed, of course he was found innocent, the parents took O.J. to civil court and sued him and actually won. Eighth Amendment is about bail and how it is set. Bail is money that you pay to get out of jail while you are waiting for your trial or a criminal charge. The money is returned to you when you show up in court. In essence, this means that the punishment and the bail set amount needs to fit the crime. So you can't be charged $10,000 for bail for parking in a tow-away zone. That would be unfair. And it also protects against cruel and unusual punishment. So in other words, criminals aren't used for medical experiments while in prison, and while you are in prison, you have to be treated accordingly. But there is the argument on, does the Eighth Amendment really protect from cruel and unusual punishment? 31 states still have the death penalty, and some argue that the death penalty does fall under cruel and unusual punishment. This is often a personal view, a hot topic button for many, and it will never really be settled because it does fall to the state's jurisdiction, and that is left up to the voters and the Congress of a state. Our Ninth Amendment talks about the rights of people. So what rights do we have as individuals? So these are any rights that are not spelled out specifically in the Constitution. So in other words, the Constitution doesn't say you have to use a particular internet service. So the government cannot deny you that choice. You have the right to own a pet, unless you live in an apartment that specifically eliminates pet ownership. You have the right to privacy, and you have the right to engage in a heterosexual activity, and you have the right to an abortion, and you have the right to contraceptions. So we can look at this slide and see some of the major Supreme Court cases that has protected rights throughout, and Roe versus Wade is probably the most famous case to many of you, but if you have time, you should look through some of the other cases there because they are very important and they gave us the right to behave and do certain things that we choose to as American citizens. Finally, we have the 10th Amendment, and this is supposed to mean that if the rights were not spelled out specifically in the Constitution, then these rights belong to the states. For example, the Constitution is silent about driving a car. The power to grant license for driving is a power left to the states. Each state has its own laws, which is why you can drive a car by yourself at age 15 in South Carolina, but you have to wait until age 16 in Florida. So that kind of ends up in a nutshell some of our, or actually all of our Bill of Rights. And if you have any questions, please let me know.